Good morning and welcome to the Supreme Court of the United Kingdom. Today we are hearing an appeal from the Inner House of the Court of Session in the appeal of Anwar and the Advocate General for Scotland. The appeal arises out of a judicial review in which questions as to whether the Scottish courts have power to grant an interim remedy to freeze the assets of a respondent in support of an EU law-based claim in the Employment Tribunal. And also, if they do have such a power, whether such a power meets the requirements of EU law as to equivalence and effectiveness. The appellant is represented today by Mr. Aidan O'Neill QC and Mr. Scott Blair, and the respondent by Mr. David Johnson QC and Mr. John McGregor QC, and the intervener, who is the Equality and Human Rights Commission, by Ms. Christine O'Neill QC. Before inviting Mr. O'Neill to begin his submissions, may I introduce the panel. I am Lord Hodge, and sitting with me today is Lord Lloyd-Jones.
Good morning.
Lord Briggs.
Good morning.
Lord Leggett.
Good morning.
And Lord Burrows.
Good morning.
I now invite Mr. O'Neill to begin his submissions.
Well, obliged, my lords. The issues have been set out fairly fully in the cases, and really I was hoping to use the 2 hours I have really to respond in a sense and clarify some of the issues which have arisen in relation to the approach which is taken by the respondent in their case and in the courts below. But in short and unusually for me in this court, I say that the Lord President, Lord Carloway in the Court of Session, reached the right decision in his dissenting judgment in the court below, and that the majority, Lord Drummond-Young and Lord Malcolm, got needlessly lost in the obscurer byways and thickets of historic 19th century Scots law, and perhaps lost sight of the bigger picture in this case, which is a straightforward case as to whether or not the United Kingdom has properly implemented the equality directives which underpin the petitioner's original complaint before the tribunal. So basically, this is what might be called a private enforcement action by the petitioner, who clearly has sufficient interest to raise the matter, to bring the UK authorities to account before this court because of their failure fully and properly to implement the equality directives, in particular the remedies provisions and the dissuasive sanctions provisions, which are common to all 3 of the directives which were relied upon in this case before the tribunal. As the court will recall, the case was one which alleged discrimination and victimisation on a number of protected grounds, including race, ethnicity, religion, and sex. The grounds apart from race and ethnicity were upheld, and a substantial amount of damages was awarded to the petitioner, as well as, unusually for the Employment Tribunal, a substantial award by way of legal expenses or costs, some £20,000. But none of that ultimately was able to be enforced, and the debt remains unpaid because of the approach which was taken by the employer to move funds out with the range of recovery. So it's that failure which has resulted in this action. So, of course, the petitioner is not directly seeking to enforce and vindicate her equality rights. She sought to do that against her private employer, but what she's relying upon here is the fact of the failure of the sufficient provision in national law to implement her rights of effective remedy and dissuasive sanction. That's all we're concerned about in this case at this stage. The question of causal links to and quantification of her loss, because this is the first step in a Frankovich damages action, have yet to be determined. And at the permission stage, when this first came to judicial review before the Outer House, the Lord Ordinary refused in hoc statu the issues around damages on the basis that the petitioner had to establish the legal point first. Was there a sufficiently serious breach of EU law in terms of implementation, which would then open up the second and third issues of causal link and quantification of damages. Now, of course, we're talking about...
On that basis, Mr. O'Neill, would I be right in saying the assertion that the employer has moved funds out with the range of recovery at this stage is simply an assertion? But it's not an area that I've got to go into.
No, absolutely. Well, it's not simply an assertion. I think we've set out. It's in a sense it's the sine qua non as to why we're here. Because if we'd been able to arrest the funds or obtain the funds, then we wouldn't be here. And we say that's what happened to us, and we've set out in the various affidavits from the instructing solicitor as to precisely all the steps we took, including interdict and the like, but we couldn't arrest funds on the dependents in the hands of, which were clearly there in the hands of the bank and the like. And Ms O'Neill, for the intervener, will be and has produced evidence to say that this is actually a systemic problem. This is not a problem peculiar to our situation, but there is an issue, that's important evidence, and it's relevant evidence in the context of this being a private enforcement of an implementation action, of a failure to implement. But Ms O'Neill will speak to that evidence and the affidavit supporting that. But your lordship's correct. We don't have to, in a sense, consider the particular facts of this. It's a pure question of law. The facts are relevant background, of course. They give us a standing to allow us to take this private enforcement action. Now, of course, we're talking about EU law here, and you might think post-Brexit, what has that to do with anything? I think it is accepted that because this case was raised before, while indeed the UK was still a member state, the provisions of the 2018 Act are such that the issues of EU law are still live ones for this court. And also, of course, the decisions of the Court of Justice are matters which the court has to have regard to and generally follow. The one change is, of course, that this court can no longer make a preliminary reference to the Court of Justice. The other point which is made, and simply by way of contextual background, is that, of course, we now also have the Trade and Cooperation Agreement between the UK and the EU. And one of the things which that says is that there should be a preservation of the levels of protection of fundamental rights within the workplace. And this case would fall within that heading of fundamental rights in the workplace. And therefore, what that shows that this case is not simply of historic interest, that at some levels the decision of this court can also be seen not simply as stating how the law was, but by stating how the law is, it's setting a baseline for the purposes of the future trade agreement, the Trade and Cooperation Agreement.
Yes, it is a matter of common ground that we are to apply EU law in this context. So, and you've set out clearly in your case your position on that matter, but I don't think you need to detain the panel in detail on that, as it's a matter of common ground.
Absolutely, I'm obliged, my lord. But as I say, the important thing about this case, and it sometimes seems to have been rather lost in the courts below, certainly in the majority, is that this is about the implementation of EU directives. This court is essentially exercising the same constitutional function as the Court of Justice would be doing if there had been an enforcement action taken under Article 258 of the treaty directly by the Commission to the Court of Justice. And that's not something which can be done now, but the fact is, from the point of view of the relevant case law for these purposes, given that we are challenging how and whether they have properly implemented the provisions of the directive for the purposes of EU law, is that implementation case law. What the other thing which the parties are in agreement with, in a sense, which makes the issue more legally focused, is that parties are in agreement that for the purposes of proper implementation of the sanctions and remedies provisions of the directive, there has to be a procedure allowing for interim protective measures to be pronounced by a court in favour of an individual. And basically, the respondents say, well, we do have that because of this case law from 1842. And I say that that's not one. I don't think that, in fact, does give the jurisdiction which you claim exists. And in any event, even if it did, it wouldn't be proper implementation of the directives. No, it's but one of the other issues between us is that we are agreed that there has to be some kind of provision for interim protective measures to be granted by a court. And the position which I take is that the Court of Justice's case law is to the effect that it is the court which has been seized with the relevant dispute, court or tribunal, as a matter of national law, which should be the court or tribunal which is in the power to grant the relevant interim relief. And I rely in that regard on two cases, which I think are worth looking at very briefly at this stage, and we'll probably come back to them. But first of all, the Commission Against the UK and the Aarhus Compliance, which is in tab 44 at page 1996 of the electronic bundle. And it's in volume 3. I don't know if anybody's using the old hard copies.
Mr. O'Neill, none of us have hard copies anymore, so you need only refer us to the electronic paginate.
Yes. Well, I'm the only one with paper, but it means I can stick with my computer, which has my submissions. So, well, at page 2028 of the electronic bundle, sorry, Melissa, I'm having difficulty locating these things as usual. Too many things on. This case will be familiar to your lordships. It's the implementation, the Article 258 direct action before the Commission, which arose out of whether or not the Aarhus Convention provisions on non-prohibitively expensive court proceedings had been properly implemented in the UK. Of course, this came before your lordship's court in the case of Edwards, in which a reference was made to the Court of Justice, a preliminary reference. This is the same issue, but it's as taken by the Commission, because the basic position was that the Commission were not satisfied that the case law was sufficiently clear to, in fact, constitute proper implementation. But at this stage, all that I'm taking from what the court says is at paragraph 65 of the electronic bundle 2028, where it says it is apparent from settled case law that a national court seized of a dispute governed by European Union law must be in a position to grant interim relief in order to ensure the full effectiveness of the judgment to be given on the existence of the rights claimed under European Union law. And then it goes on, that applies in environmental law. Now, that's what it says there. And I say that's not insignificant. It's that the court itself, which is seized with the substantive dispute, should have all the power to ensure the full effectiveness of EU law by way of proper implementation. and that you do not split the, as it were, jurisdictions of and powers from one court to another, one to determine whether or not EU law has been breached, as it were, and another to determine what remedy might be given to ensure effectiveness of it. That is not what is envisaged in the Aarhus case. My Lord Rakes is asking a question.
Mr. O'Neill, was there any issue in that case about whether a division of court between the court determining the dispute and the national court granting the interim relief fell short of that European requirement? Or was it simply a question about whether the courts of a member state should have interim relief available?
It was in that case about the courts of a member state. It was the latter, but which is why I'm taking your lordships now to a case where there was specifically the issue of split jurisdiction, which was then raised, and that is the case of the Workplace Relations Commission case from Ireland, which is at tab 14, page 1247 of the electronic bundle, and I'm going to look particularly at page 1277 to 8. Just by way of background, in this case, Lord, this was a case in relation to the extent of the jurisdiction of the Workplace Relations Commission, which had been set up under Irish law effectively to deal with discrimination claims. It was held to be by the Court of Justice a court for the purposes of Article 19 and Article 267, because it was the court seized under national law with the enforcement of the directive. In that case, it was discrimination on grounds of age. And one of the issues which then arose was that there was a conflict between the requirements of the directive and the national law, Irish primary statutes. Now, under the Irish Constitution, the constitutional jurisdiction of striking down or declaring to be unconstitutional acts of the Irish Parliament, the Oireachtas, is reserved to the High Court, and then the Supreme Court. There's now, of course, an intermediate Court of Appeal. But in the Constitution itself, it's a High Court matter, and it is not, therefore, a matter which statutorily constituted tribunals created under the Constitution by the Dáil, by the Parliament, have jurisdiction under the Constitution. So it was said that the Workplace Relations Commission, then, as a matter of constitutional law, could not disapply the law. That would be unconstitutional. It could declare that there was an incompatibility, but it did not have the power to grant the relevant and effective remedy, because that was reserved to another court for constitutional reasons and as a matter of history. And the court said, when the reference was then made by, I think, the Supreme Court to the Court of Justice, that that wasn't good enough. That because of, they said, you cannot invest a court with bits of jurisdiction in terms of determining the substance of the case, but then deprive it of the opportunity of giving effet utile, useful effect to the provisions of EU law within the national legal order. Now, it's important because this case was referred to in the court below, and Lord Drummond-Young distinguishes it, says, oh no, that's all to do with primacy of EU law, and it's not to do with granting diligence for ongoing cases or cases on the dependents. It's not. The whole notion of primacy, the whole creation of the idea of primacy, of direct effect, of indirect effect, of Frankovich damages, are all to do and are all tied up with making sure that EU law is effective within the national order. So primacy is just simply one example of that. So this is just an example of that general principle of effet utile, which is exactly the same principle which was referred to in the Aarhus case. So the relevant paragraphs, as I say, are at page 1277 to 1278, the paragraphs 46, 48 and 50. And the quote there just says it would be contradictory if an individual were able to rely upon the provisions of EU law in a particular area before a body which had been conferred jurisdiction under national law, but that body were under no obligation to apply those provisions by refraining from applying provisions of national law which conflicted with it. Para 47, they can confirm that the Workplace Relations Commission is a court entrusted by law and recognised as such as a matter of EU law. Paragraph 48, it notes that it would be, importantly, it says that the Workplace Relations Commission is entrusted by law to ensure the discrimination directive is implemented and complied with. If they were unable to effectively disapply a national provision, country-national provision, says the EU rules in the area of equality in employment and occupation would be rendered less effective. Now, this is important. It's less effective. It's the less effectiveness as part of the effet utile. They're not saying it wasn't possible to. It was perfectly possible to have a disapplication, but it would require another application to a different court. And then it then goes on, paragraph 50, in the usual way, it follows from the primacy of EU law that bodies called upon to exercise, within the exercise of their respective powers to apply EU law, are obliged to adopt all measures necessary to ensure that EU law is fully effective. So that's what is required in terms of the proper protection of EU law. It's got to be fully effective before the courts or tribunals which are charged under national law with the jurisdiction of determining whether or not there has been breach of the law. Again, in paragraph 50, the court says bodies, to ensure that EU law is fully effective, must neither request nor await the prior setting aside of a provision by legislative or other constitutional means. So what that means is that it would be incompatible and not a proper implementation of EU law if that situation were to stand. And consequently, the court says, as a matter of paragraph 52, the answer to the question, having regard to the primacy of EU law, is that the national body established by law in order to ensure enforcement of EU law in a particular area, if it lacks jurisdiction, it has to be able to disapply a national law rule. It would be contrary to EU law to not give the tribunal that jurisdiction, which is important. So it's directly, frankly, I say, on all fours with where we are with this splitting of jurisdiction. Even so, from the implementation perspective, it's entirely clear. Keeping the focus on this being an implementation case, of course, the point. Oh, I'm sorry, my Lord Briggs, I wasn't looking. Yes,
Mr. Neal, can you help me from your greater knowledge of the detail of this case? In paragraph 50, it refers to it being unacceptable for the court charged with the implementation of EU law to have to request or await the prior setting aside of such a provision or such case law by legislative or other constitutional means. I think we probably all know what legislative means, but does other constitutional means within the context of that case include by an application to another court?
Yes, it does. It was precisely that. It was the application to the High Court, which had the constitutional jurisdiction under the Irish Constitution to disapply.
Thank you.
So, as I say, because this is an implementation case, one of the important things also to keep in mind is it is a question for the respondent to satisfy the court that the UK authorities have fully, duly and properly implemented international law, the appellant's right of access to these interim protective measures. I say this because, and I'll come back to it, at points in the respondent's case, it seems to suggest we haven't proved our case. It's for them to prove that they have properly implemented the rights that we have, and it is agreed that proper implementation means giving access to interim protective measures. And I say proper implementation means access to implement proper protective measures within the context of the very tribunal which is charged under national law with deciding the substance of the issue. Now, I think it's said on the other side, yes, but look at the terms of Article 288 of the treaty. That says, in terms of directives, the choice and form of methods for the implementation of a directive is a matter for national authorities. And of course, that's true. Choice and form of methods is, but it doesn't mean to say that the choice and form of methods is entirely untrammeled. One has to actually take into account what those requirements are in terms of, that's where we get these ideas of effectiveness, but not just effectiveness, but clarity and accessibility of the implementation. And in that regard, it is again worth going back to the Aarhus case, which I mentioned earlier, and look in this at page 2024 of the bundle. Paragraphs 33 to 34, the court sets out the general principles which are repeated throughout this general implementation case law. That is to say that the transposition of a directive doesn't necessarily require the provisions of a directive to be enacted in precisely the same words in a specific express provision of national law. And a general legal context may be sufficient. Now, look at all these words qualify. It may be sufficient if it actually ensures the full application of the directive in a sufficiently clear and precise manner. That's a very, very high hurdle. If you are not actually specifically implementing international law, which in a sense it's presuming you will do, echoing the wording, if not the cut and paste that was once the fashion in UK drafting. Exceptionally, it might be that you can say, oh well, we've already implemented it because we've got a strong body of case law which makes it clear what those rights are. But it goes on, and it gets even higher as a hurdle in terms of where you reach in terms of implementation. It says that paragraph 34, in particular, where the relevant provisions is designed to create rights for individuals, the legal situation must be sufficiently precise and clear, and the persons concerned must be put in a position to know the full extent of their rights, and where appropriate, to rely upon them before the national courts. Now, the rights include the right to seek interim protection, of course, because we've already established that from paragraph 65 in this case. But going on, then, what the court says at paragraph 56, page 2027, within the context of an implementation order, implementation action, it says, in that regard, the mere fact, now this is central, in a sense, this is all I need to say, and then I can close my case. I won't, but this really is a central point. The mere fact that in order to determine whether national law meets the objectives of the Aarhus effective Aarhus directive, the court is obliged to analyse and assess the effect, which is moreover subject to debate, of various decisions of the national courts, and therefore of a body of case law. Whereas European Union law confers on individuals specific rights which would need unequivocal rules in order to be effective. And that leads to the view that the transposition relied on by the United Kingdom is in any event not sufficiently clear and precise. And that is precisely the situation we have here. There has been no transposition, no implementation of the undoubted right to interim protection in terms of employment tribunals. There's no statutory provision saying if you're seeking interim protection for rights in applications of employment tribunals, go to the Sheriff Court or go to the Court of Session, or here is the power in the employment tribunal. There is nothing of that sort. Instead, what we get is antiquarianism. Why? Well, of course there's this, right? Look at these cases in 1842. I mean, it's astonishing if one didn't know that traditionally in Scots law, the older a case is, the more authoritative it is, on the basis it gets closer to the golden age of Viscount Stair. But that's not how a modern legal system works, frankly. And Scots law doesn't usually fall back into those old attitudes, but it seems to have done here. Well,
Mr. O'Neill, it might be said against you that this was the decision that you're praying in aid, which I accept was from 1842, was a decision involving the consulted judges of the whole court.
Yes, but don't worry, I'm going to, insofar as I could actually understand it. I mean, I did history of Scots law. I should be on top of all this. But when we look at it in any event, it doesn't actually bear any of the weight which is now placed upon it. And even if it were the case that there was this jurisdiction, the Fordyce-Hawkins jurisdiction, which frankly I do not think is the case, I very much doubt, it most certainly is not sufficient implementation for the purposes of EU law and the Aarhus case on that. If you've got to start going through the dusty old textbooks to try and work out what your rights may be, that isn't the clear and precise implementation of rights, individual rights. And we're absolutely clear on this. These are discrimination directives which are intended to give full and effective protection against discrimination within the workplace. There's no doubt or equivocation about those being individual rights, and the right is one of effective legal protection of those rights. And that's not done by saying, well, if you put on, as I say, your pince-nez and go through and look at early 19th century case law, you'll find it's all perfectly clear from that. It isn't, but even if it were, it's still not proper implementation. And we've got lots and lots of cases, and I'm not going to hold back the court with many more of them, but the point is absolutely made that relying on case law, even if you had a clear and absolute line of case law, that in itself would still not be sufficient. And we don't even have that. But so a case in which, again, the Dutch courts in an implementation action, Commission against Netherlands, tab 43 at page 1865, there is, the court there looks at and rejects the defence put forward by the Dutch authorities, saying, well, but it is entirely clear as to what is meant, because we've got a consistent line of case law, which we don't have in this case. But even that is not sufficient. So at page, this was an implementation action in relation to the provisions of the Unfair Contract Terms Directive, that things had to be written in plain and intelligible language. And the court states at page 1873, paragraph 21, it says, as regards the argument advanced by the Netherlands government, if the Netherlands legislation were interpreted in a way to ensure conformity directive, so that's the principle of indirect interpretation, principle endorsed by the High Court of the Netherlands, it would be possible to remedy any disparity between the provisions of Netherlands legislation and those of the directive. It's sufficient to note the Advocate General explained, even where the settled case law of a member state interprets the provisions of the national law in a way deemed to satisfy the requirements of the directive, that cannot achieve the clarity and precision needed to meet the requirement of legal certainty. And that's particularly the case in consumer protection, and therefore there was a failure in implementation. So settled case law, even informed by the Marleasing-Lickster approach of conforming interpretation, is in itself not sufficient to constitute implementation. Now, I think it's important at this stage just to highlight, because I think it was something which confused the Lord Ordinary, is that because this is an enforcement action saying that there has been inadequate implementation as the first step in a Frankovich action, it is for the national authorities to say, no, we have properly implemented this, look how we have done it. But in so doing, the national authorities cannot rely on, as we've seen the Netherlands authorities trying to rely on principles such as direct effect. We don't have to implement it because, look, the individuals can rely on these rights anyway, or indirect effect. We don't have to implement it properly because our courts will read and add in words where necessary to ensure that the rights are protected. The national authorities cannot rely on those principles because those are principles which are swords for individuals to ensure that even in the face of inadequacy or absolute failure on the part of the national authorities to comply with their EU obligations, there will still be a chance to get one's rights protected before the courts. But that does not allow, it is not a shield, the indirect effect and direct effect is not a shield for national authorities to say, it doesn't matter how badly we implement them or how obscurely, there is a form of implementation in terms of the Hawkins and Fordyce case law, and that's sufficient. It is not sufficient because it doesn't achieve the clarity and precision needed to allow individuals to know exactly where it is they stand on these matters. So those are the tests. And although this case law was put before the Inner House and is referred to in passing by Lord Drummond-Young, he says, "Oh well, that's got nothing to do with this case because we're dealing with a doctrine of Scots law that applies across the board, and so it doesn't have to be clear and precise in the manner adumbrated by the court in these decisions." That's simply unsustainable, frankly. If you are, as my learned friend Mr. Johnson is saying, that this Hawkins 1842 case law is the implementation, then it has to comply with the requirements of legal certainty, of clarity, precision and transparency, such that people can rely upon those rights before the court. So what we can, drawing those cases together thus far, note that not only then have we a supposed implementation which is utterly unclear, imprecise, and is found only in the case law from 1842 onwards, which does not comply with the requirements of EU law in terms of the clarity. It is also case law which has not been effective in dealing with the very issue which it's supposed to deal with, which is effective protection of these rights, because we have this astonishing remedy gap or enforcement gap, as is clear from the evidence which the intervener has put in, which again was referred to in the court below, and Lord Drummond-Young said, "Oh, well, it's unfortunate, but it's probably due to insolvency of employers." One cannot dismiss the evidence which is to the effect that employment tribunals' orders are not being able to be enforced. And one of the reasons for that has to be that the employment tribunals don't have the power to order the protective remedies necessary on the dependence of applications before them. So there are harmful effects. Sorry, my Lord Legate. Lord Legate.
Sorry, I had to wait to be unmuted. And then I was just wondering how far you take this, Mr. O'Neill. I mean, do you say that the employment tribunal has to have all the enforcement powers that the court would have, like ability to grant charging orders over people's houses to enforce its judgments and ability to send in the bailiffs. I don't know what the procedure is in Scotland, but in England, something called a writ of fife that the High Court can issue to seize somebody's goods. I'm sure there's similar sort of remedies. Do you say the Employment Tribunal has to have the whole panoply?
What I say is that the Employment Tribunal, well, first of all, I say that there has to be an availability of rights which is clear within some kind of, and I say in this case, it's got to be a statutory provision which says that employment tribunals orders applications on the dependents for the employment tribunal can be protected by arrestment orders under the following means, and there just isn't any of that. Now, I say in addition, ideally, that given the Aarhus case law, it should be the employment tribunal which has those powers of at least arrestment on the dependents. And then the issue is, then it gets into the obscurities of having arrested funds on dependents. How then do you have the mechanisms for arrestment, as it were, getting the money by way of execution? And as your lordship pointed out, by getting where then do you go with it with enforcement? And there are all sorts of old Scots law remedies of having multiple or pendings, rather, I suppose, and routes and messengers at arms serving things and all the rest of it. Now, we know that the Employment Tribunal is integrated within the court system. We have appeals to the Employment Appeal Tribunal and clearly to this court. So, but I'm not a legislature, and neither is this court. All this court has to say is what they have put forward by way of justification is not an implementation. But this court doesn't have to say, and this is what implementation would be, because it's going beyond its own constitutional function. So that's why I say the onus is upon the respondent to show that they have overcome the requirements of clear and absolute implementation. Now, that it doesn't, as I say, I'm not here to legislate and say what powers an employment tribunal might or might not have. I say it rather looks pointing to the Aarhus case law that it should be the employment judge who has the right to grant these remedies ad interim. And I think my learned friend's best point really is at paragraphs 59 and 60 of his case, where he says, oh, but the English Law Commission didn't think that was a good idea because it would need more training for employment judges. Well, somebody's got to be trained because these are, the alternative is to say, well, the sheriff in Scotland, Sheriff Court deals with it, but the Sheriff Court is not trained in the specialisms and the complexities of equality law as it applies within the workplace. They have no jurisdiction on those matters. And the complexity of issues around discrimination law are already such that there is provision when it comes to goods and services discrimination, which the sheriff does have jurisdiction over, for the appointment of assessors who are aware of and understand the complexities of EU equality law and have some experience of the notion of discrimination. So yes, there is going to have to be training, but if and insofar as it requires employment tribunal judges who are legally qualified to be told the criteria upon which arrestment on the dependents might be granted, which it's basically is there a prima facie case, or in terms of the merits of your case, and it's employment tribunals who are specialists on that, not sheriffs. And is there sufficient evidence to justify granting the order, and the basis is there evidence of attempts to salt away funds or a possibility of virgins ad inopium on the verge of bankruptcy or contemplating fleeing the jurisdiction. So the tests aren't that difficult, frankly, but in either way, somebody's going to have to be trained up on this. But I don't have to say how. My Lord Burrows.
Yes, thank you. It I think follows on from Lord Legate's question. I'd just like to take you back to the Ministry of Justice and Workplace Relations Commission decision, because I'm looking at what Lord Drummond Young said at page 167 of the electronic bundle, paragraph 72 of his judgment, where he distinguished that case because, in effect, he was saying it was dealing with whether or not the Workplace Relations Commission could comply with the supremacy of EU law over national law. And he said, well, that's obviously a different matter entirely from, I think, the broad proposition that you seek to get from this case, which is that any tribunal with the claim must also have all the protective and supportive measures that might go with that. And I just wondered what precisely you say about his distinction.
I thought I dealt with that, Lord, but I'll deal with it again. Is that the distinction is a distinction without a difference, because the notion of the primacy of EU law, which is your lordship's aware, was pronounced by the court in Costa against Enel in 1963, was a statement by the court which was made in the context of ensuring the full effect of EU law. So primacy in and of itself is simply one aspect of ensuring effectiveness. And what is being said here, that if you have a court dealing with the substance of a case, it has to have rights to ensure effectiveness. And that doesn't mean those rights are restricted. It happens to have been analysed in this case in terms of the supremacy of EU law, such that the Irish Constitution's provisions of having to go to the High Court would not be applied. But the same principle applies, as we've seen also from the Aarhus case, that it's up to a national court as to which court or tribunal gets to determine EU law derived matters, and in this case it is and is only the Employment Tribunal. We know that from the terms of the Equality Act. Now, doing that, is it proper implementation to give them that power, but not give them the power for any kind of protective order? And I say no, because just as the Workplace Commission didn't have the power to disapply, this doesn't have power to freeze monies, and so there's a failure in implementation. But as I also underline, my lord, it doesn't, at some levels, it doesn't really matter, because on the implementation case law which we have, which have gone through about clarity and certainty and not having to go through reams of past case law, it is clear that what there does require to be any form of implementation is a statement, a clear and unequivocal statement, that somebody has the jurisdiction to make the necessary protective orders when it comes to employment tribunals. Now, I say it's likely to be employment judges, but it might be other judges. It might be, or there might be some kind of new provision. But it isn't enough to say, well, in 1842, in Hawkins and Fordyce, the full court said this about a dispute about a landed estate in Scotland. That isn't implementation, whatever it is. So I don't have to go as far as the Workplace Commission's case, and I say that Lord Drummond-Young's distinction of it is not substantive and doesn't hold up to proper scrutiny. So where was I? But I do say, I mean, we can call it the one-stop shop, really. The one-stop shop is perhaps the ideal. Certainly, it's what's presumed in the Aarhus passage, paragraph 65. That would be the ideal way of doing it. But it still requires there to be a formal statement of law to the effect that there is this one-stop shop. I mean, there are alternatives. It could be, for example, that the sheriff is granted, if you're seeking interim protective orders, exceptionally then the sheriff can grant them, but also will have the opportunity and the duty to hear the substantive case. That would comply with the one-stop shop. So as I say, I'm not putting forward any particular legislative solution. I'm just pointing out there is a major problem in the failure to implement, and that's all I have to do. The major problem is sufficient for there to be a breach of EU law. And in the circumstances of my case, that's enough for me then to go on to prove causal link and quantification of the loss which arose from that breach of EU law. So that's all I'm interested in, at the breach, rather than establishing what would not be in breach. So, as I say, because this is focusing on the failure to implement, the onus is on the respondent to show that they have properly implemented. But the respondent seems to have forgotten this. And certainly from the chance of their case, they show what can only be described as certain chutzpah in their approach, saying that, paragraph 31, there's a flaw in the appellant's argument. The appellant has singularly failed to demonstrate that the requirement to raise parallel proceedings is excessively difficult or otherwise renders the remedy ineffective. We say, I mean, it's getting in the realms of the ridiculous. We say there was never any such remedy, which they came up with only in the original judicial review, and then they're saying to us, "Oh well, the remedy that we say doesn't exist." They then complain we haven't demonstrated that this non-existent remedy is really expensive. They're the ones that have to set out that the remedy they claim follows and all the requirements of EU law. And so it's when they go on then at paragraph 33 of their case to complain that this appeal proceeds on anecdotal arguments rather than concrete facts. Yes, the anecdotal evidence are the claims made by the respondent. The concrete facts are the facts that should have been proved by the respondent to show that this is effective implementation. They're the ones with the responsibility to show clear and cogent evidence and material to support their assertion that this was adequate implementation. It is not for us, as the petitioner, to say this is, we can second guess the appellants and point it out. But in any event, the intervener has produced cogent evidence and affidavits spelling out precisely what additional requirements putting in, going to the Sheriff Court, in addition to staying in the Employment Tribunal for the substantive case, would cause. So, but I do call out the respondents for their statements in paragraphs 31, 33, 34, 38 and 39, all of which are predicated upon what they claim are the appellant's failures to demonstrate that the available remedy was ineffective. That's not my job. They're the ones who have the duty to show that the remedy was effective. We have nothing to prove. It's the respondent who has to prove these matters. But what I can do to assist the court is to examine carefully what has been said by the respondents as what they claim to be the effective remedy, and actually point out that simply their claims, when looked at, raise far too many questions. Again, I don't have to say or prove for the purposes of establishing the first step in the Frankovich case that my complaints against this supposed alternative remedy are in fact well-founded. It is enough from the point of view of challenging the cogency and clarity of their supposed implementation to say there are significant doubts about whether or not this is in fact an available and effective remedy. That's enough, as is clear from paragraph 56 of the Aarhus case. The matters are debated, and the reason that matters are debated is that this invented remedy, rediscovered since 1842, has never been put into practice. It is wholly untested, utterly theoretical, and as I say, is, if anything, an antiquarian exercise. There have been no cases whatsoever that can be pointed to. There is one, interestingly, there is a reference in the materials produced by the intervener of an affidavit of one solicitor who, since the judgment of Lord Tyre, saying actually there is this remedy, actually tried it out and found out just how much expense was involved in it, and it was significant, and it's set out in her affidavit, which is at page 664 of the court bundle. We don't need to go to it, but even in that case, the claim was never tested, because all that happened was, as soon as it was raised, then the employer then entered into negotiations and offered proper guarantees and the like. So the respondents can point to no case, absolutely nothing whatsoever, in which any court, whether a sheriff court or the Court of Session, has ever granted remedies, interim remedies, protecting an application before the Employment Tribunal. So that is enough, in a sense, to say, well, then they haven't implemented. But more importantly, then, so I just want to look at critically then their supposed implementation. And as I say, all I have to do is raise doubts about it, of which there are plenty. First of all, the respondent says that there is effective implementation of the interim remedies protection in the sheriff court. That is the case in their pleadings. They're saying, actually, all you had to do was go to the sheriff court, because there is this Hawkins Fordyce jurisdiction, which now Hawkins and Fordyce, which are referred to and relied upon by the respondents, are two cases from 1842 in the Court of Session. They both are Court of Session cases. Then they don't deal at all with the issue about the jurisdiction of the sheriff court. The cases have been referred to in the leading authority on Court of Session practice, McLaren, which I don't know, is it 1960s? McLaren, the author, calls those cases of doubtful authority. Okay, so there's already some debate from the leading Court of Session authority. But if we then look at the cases, what are they about? They're about rich man's law, basically. It's to do with disputes over landed property, which is situated in Scotland, among other places. So a case is raised in England disputing issues around ownership of various assets. Among them include land in Scotland. So against that background, in 1842, it makes perfect sense that the Scottish courts will say, we have jurisdiction. We have jurisdiction because this is about Scottish lands, and the one thing that we know about is Scottish land. We don't know what's happening in the English proceedings, but the fact is, we undoubtedly have jurisdiction by reason of the situation of the land in Scotland, and that basis of asserting jurisdiction is something which has been since codified, as we know, in the Civil Jurisdiction and Judgments Act 1982, in disputes between in intra-UK disputes on jurisdiction or intra-UK cross-border issues, in terms of disputes related to immovable property or tenancy in immovable property, then the courts where the land is situated have exclusive jurisdiction, in fact, under paragraph 11 of Schedule 4. So Fordyce and Hawkins are dealing with cases in which the Court of Session has a form of jurisdiction, even if it doesn't have, it says, knowledge of and jurisdiction over all of the substantive issues which are argued in the courts elsewhere. It does have a basis of asserting jurisdiction. The other case, which is referred to by Lord Drummond-Young as somehow an application of this 1842 jurisdiction in 1982, so, well, they were doing it just 140 years later, is a case called Motor Drift, which I don't think we need to go to it, but it's at tab 9, page 1135. Now, this is a case which is before the Civil Jurisdiction and Judgments Act has come into force, which, of course, codified rules of jurisdiction in both Scotland and England. It is a case which involved a commercial dispute between a Norwegian company and an English-based company, but there were some funds in Scotland. So what then happened is that there was an application, there was an arrestment of that movable property to found jurisdiction. Now that was what you could do under Scots common law. If you had money movables in the jurisdiction, then you could hold on to that, and that would allow the courts, it would cook on and allow the courts to have jurisdiction over the matter. And that's the jurisdiction that was exercised in that case. So again, we've got a situation where, as in Fordyce and Hawkins, they had jurisdiction because there was land in Scotland. In this case, there is jurisdiction on the basis of arrestment to found jurisdiction on the basis there was monies in Scotland. Now, that arrestment to found jurisdiction has been described as an exorbitant jurisdiction. It was one which was seen to be incompatible with the provisions of the Brussels Convention and subsequent regulation by those who reported on it. And it was therefore abolished as between intra-EU cross-border matters and also as between intra-UK cross-border matters. So we've now got an abolished case in which a case in which jurisdiction was claimed in this case, which has since been abolished because of its exorbitant nature. I will come on to the fact that
Lord Jones would like to ask you a question, Mr. O'Neill.
Sorry. Yes.
Does it? I'm sorry, Mr. O'Neill. Does it appear from any of these cases, Hawkins or Fordyce or Motor Drift, that the existence of jurisdiction in the Scottish courts over the substance of the dispute was a precondition to the grant of ancillary relief?
Well, no. What it shows is that there had to be the basis for asserting a kind of jurisdiction, and that kind of jurisdiction is, and I'm pointing out the basis upon which that was asserted, because what we've got from the other side is there is a free-floating jurisdiction to grant ancillary matters to help courts in other jurisdictions or to assist lower courts. But that isn't the case when you look at the facts. On the facts of it, the Scottish courts in Fordyce and Hawkins had jurisdiction because of the lex situs, but they then said, we don't have to concern ourselves and we can wait on the determination in England and then we will enforce it. We don't, so you don't, we've protected the lands meantime, but we're not doing it because of an ancillary jurisdiction as such. We're doing it because we have jurisdiction on the basis that lands are within our territory. And well, similarly,
that's my question. Is this identified as a precondition to the exercise of the jurisdiction? Yes, there should be jurisdiction over the substance of the dispute.
The jurisdiction is, it's not over the substance of the dispute, my lord, but what I'm saying is that what has been called by the respondents as an ancillary jurisdiction is not a free-floating jurisdiction. It is itself anchored. The courts in the first instance have to have a basis on which to assert a jurisdiction and then to then exercise this supposed ancillary function.
But such a jurisdiction would be present in the sheriff court in the case of diligence in this case, would it not?
No, I'm coming on to that. I'm sorry, I'm rather trying to unpack the obscurity of the Scots law, but that is precisely what I'm coming on to.
I'll wait in that case. Thank you, Mr. O'Neill.
It won't take very long. I'm about to get there, but
I'm sorry.
Before you get there, can I follow up what Lord Lloyd Jones is saying? Yes. In the Motor Drift case, the defender was a foreign body. Is that right?
Norwegian, no, English, I think. Yes.
It was English, but yes, but so there was no
that counts as foreign.
Well, it would in terms of jurisdiction if it was a company resident in England. Yeah. Yes, and so there was the question whether there was personal jurisdiction as against the defender, and there was a separate question, which I think Lord Lloyd Jones was getting at, was whether or not where the arbitration was, whether the substance of the matter was being determined by an arbitration in England, whether the Scottish courts could provide a protective measure, notwithstanding that the substance of the dispute was not in front of them. I mean, these are two separate issues. Here, in the current appeal, there will be personal jurisdiction against the defendants if they were resident in Scotland. So
no, I'm coming on to that, my lord. This is why I'm trying to unpack this very, very carefully. But that's precisely my point there. First of all, there is, so let us establish what is the hook which gives Motordrift and Fordyce and Hawkins any kind of, how do they even get into the door of the court? And in Fordyce and Hawkins, they get into the door of the court because they say, this is about land in Scotland. There's a dispute about it in England, but this is about land in Scotland. So hold on to that for the moment. And when we're in court, actually, you don't really have to do anything about it. We're properly in court because this is land in Scotland, because actually something else is happening elsewhere. In the Motordrift, it's how do we get into court? We get into court because we get this arrestment to found jurisdiction on the basis of the monies. And then when they get into court, having properly got into court, you say you don't have to do anything about it because there's an arbitration going on, and that's fine. But you've got to be able to get into the court in the first place. And
but
that's
getting into court, Mr. O'Neill, is simply having jurisdiction over the defendant. Okay, arrestment to found jurisdiction has been held to be exorbitant. But the reason you needed that jurisdiction was because the defender wasn't present within the jurisdiction.
It isn't sufficient.
With respect, this seems to me to be a red herring that you're raising.
Well, I'm sorry, but I haven't pulled the red herring all the way in, my lords, because you're asking me questions which I'm trying to answer. But once I've done that, then you can see how red the herring is or not. But there it is. All I'm doing is casting doubts on the suggestions that the Fordyce and Hawkins are good precedents in this case. Now, we then know, so we looked at the Hawkins and Fordyce cases, but we then note that in the Lord Ordinary's decision in this case, at page 1193, paragraph 27, he correctly notes that the Hawkins and Fordyce cases have in any event been superseded by legislation.
Sorry, could you give me the page again? I'm so sorry, Mr. O'Neill, I missed that.
Yes, no, apologies, my lord. I've given myself. I've looked at the wrong case. It's in the core bundle, and it's the decision of the Lord Ordinary at page 193.
193. Thank you so much.
Yes. Paragraph 29. He says, after quoting Hawkins and Fordyce, despite these statements, it doesn't appear that the continuing authority of Hawkins and Fordyce was subject to review in any subsequent case. The decisions themselves are now superseded in relation to proceedings in England and Wales and Northern Ireland or any Brussels and Lugano contracting state. That's all. They were only about proceedings in England and Wales. So by section 27 of the Jurisdiction and Judgments Act. So section 27 of the Jurisdiction and Judgments Act, which is not produced, is a heading of provisional and protective measures in Scotland in the absence of substantive proceedings. And it codifies the jurisdiction of and only of the Court of Session in relation to when protective and provisional measures might be granted in support of proceedings in England and Wales and in other now Hague Convention countries, because of course as I was about to say to Lord Lloyd Jones, the 1982 Act, which was implementing the Brussels Convention and is now effectively using the Hague Convention, to which the EU is also a signatory in terms of civil and jurisdiction judgment matters. So all of that is now codified in relation only to, because that's all Fordyce and Hawkins were about, to situations outside Scotland. It's also only restricted to issues which fall within the Hague Convention, which is basically civil and commercial matters, so not land issues, not employment issues, importantly. So even if there ever was this Fordyce Hawkins ancillary jurisdiction in the Court of Session, it isn't there anymore because it's been codified, it's been expressed, and thereby has been limited by the legislature. There is no freestanding Fordyce and Hawkins jurisdiction. further, and in any event, and really, I mean, in order to have jurisdiction, my Lord Lloyd Jones and my Lord Hodge were saying, well, you can have it without having substantive jurisdiction over the subject matter issue, and that's set out in the terms in section 27 of the Civil Jurisdiction and Judgments Act. But what you do have to have is jurisdiction to order and grant arrestment in execution, which is to say you've got to be able to enforce the monies which you have frozen by make an order handing them over. And that requires there to be a final decree. Now, of course, in Hawkins and Fordyce, that's relatively easy because that's to do with land in Scotland. In Motorcraft, you've got monies which have been arrested on the basis of foundation of jurisdiction. And in both cases, in all cases, you're dealing with a court of session which has inherent and jurisdiction, even if not specified in statute. Now, and I know this is tedious, but this is what jurisdiction is about. So basically in Fordyce and Hawkins, the court of session procedure could conceivably be used as an enforcement mechanism by unsisting the case which had been sisted because the court already properly had jurisdiction on the basis of lex situs. What jurisdiction might the court of session, might the sheriff court have in this case? My Lord Hodge says, oh, well, it's just to do with being a defender in the jurisdiction. It isn't. First of all, the issue, it cannot be that because we are dealing with a case in which jurisdiction of the sheriff court in this case has been expressly excluded. And you cannot say, ah, yes, but there's still a sort of floating jurisdiction somehow under reference to Hawkins and Fordyce, which have been superseded, as has motor drift. So frankly, we have, as I say, this antiquarian look at what we did in 1842 and forgetting to look at what the legislature did in 1982. But also, and in any event, these are all court of session cases. The sheriff court is not a court of inherent jurisdiction, apart from in terms of the potentially the conduct of its own proceedings. In order to have jurisdiction, the sheriff court has to have a statutory conferral on it specifically of jurisdiction. It doesn't have supereminent, supervisory jurisdiction in the way that perhaps the High Court in England and Wales does, in the way that the Court of Session certainly has. That's what the case of Brown against Hamilton District Council was all about, which my Lord Hodge will be very familiar with, in which the issue about whether or not judicial review could be raised in the Sheriff Court was considered and it was confirmed to be found wanting in that regard. So you cannot simply assume that a common law jurisdiction, which appears to be based on the Comity of Nations, foreign courts in England deciding things, and in which a jurisdictional basis has been founded on the basis of lex situs, is therefore the basis in which to say that the Sheriff Court has those powers, particularly when the court in section 27, the only court in Scotland which has given those powers is the Court of Session. Now, we've got all these expressio unius est exclusio alterius issues come rushing in here. So not only is there no provision giving the Sheriff Court jurisdiction on this kind of matter, but there's provision expressly giving to and only to the Court of Session the Fordyce and Hawkins jurisdiction. The other line which my Lord Drummond Young uses is, well, what about arbitrations? You know, if there isn't this ancillary jurisdiction, then, well, arbitrations might not properly be looked after in the way that they were under motor drift. But again, frankly, all the legislature has come in and spoken about that. The Arbitration Scotland Act 2010 is a complete code which deals with, among other things, in sections I think 18 to 22, the issues around enforcement and recognition of foreign arbitral awards under the New York Convention, the 1958 New York Convention. And it also deals in section 10 with the jurisdiction of the courts to deal with issues in contracts in which there's an arbitration agreement. So arbitration is covered by
yes, Mr. O'Neill, will you please take us to those provisions? Thank you.
Which provisions? Sorry, my lord.
The ones of which you're speaking.
I don't think that we've got the 1982 Act in or the Arbitration Scotland Act in.
Well, that could be of some significance. That could be of some significance. If you're saying, please don't interrupt me. If you are saying that a common law power has been superseded by statutory provision, then I do think it's incumbent on you to put before this court the statutory provisions on which you found. Perhaps you will do so after the hearing. Thank you.
I will do so, my lord, but I would say that I am saying there is no such common law power, and I'm pointing out in terms of provisions that were before the court in the Outhouse. And apologies if they're not before this court, but they will certainly be provided. And as I say, all I am doing is casting doubt on the approach which was taken and pointing out that there have been subsequent statutes which apply to these issues. I am not setting up a positive case. I'm pointing out the flaws in the alternative case put forward by my learned friend. And the issue of the codification of arbitration in Scotland is, I would have thought, fairly well known, and it follows in very. But we will provide the specific provisions.
Well,
but it follows in any event the 1996 provisions in England.
Could you repeat the sections of the 2010 Act on which you're founding?
I'm not founding on them, Lord. I'm highlighting them for the court's illumination. But it's section 10, in particular section 10, subsection 2, which says that any provision in an arbitration agreement which prevents the bringing of legal proceedings is void in relation to any proceedings which the court refuses to assist. And then in terms of the New York Convention, the particular provisions of that were incorporated by sections 18 to 22 of the 2010 Act. But it's not a major point as far as I'm concerned. It is a passing comment from Lord Drummond-Young. I am not setting up a positive case, but we will certainly provide those statutes.
Mr. O'Neill, this court is fully entitled to test passing comments which you choose to make with respect. I wonder if this might be a convenient place to take our adjournment. We will resume in 5 minutes' time. All you need to do is switch off your video and mute your microphone, and we'll return in 5 minutes. Thank you. We're in a position to resume again. Thank you.
Obliged, my lord. So I was, in terms of examining the alternative remedies or the remedies suggested by the learned friend as being an implementation of the requirements of EU law, I was pointing out the degree of legislative intervention which has existed since 1842. But the last of these legislative interventions I mentioned is, of course, the amendment to the Debtors Scotland Act in the wake of the decision of Lord Drummond-Young and Carl Construction against Palisade. It was an attempt to put the issues of diligence on dependence on a properly convention compliant basis. And our position was before the court below that those provisions superseded and replaced any prior powers of the court, because effectively what one had was a codification, and that and therefore being a codification, it wasn't appropriate to go back and re-examine the older underlying authorities. And our authority for that was the case of Bank of England against Valiano Brothers, which is in the authorities tab 35, page 1539, and the particular passages are at page 1576. The court goes to that briefly.
Mr. O'Neill, Vagliano Brothers and Bank of England is about codifying legislation, isn't it?
Yes, it is. Yeah, it's about the Bills of Exchange Act.
Yes, and the question here is whether, in fact, this is intended to be a comprehensive codification.
Indeed, and the Lord President thought it was, and the Lord Drummond-Young thought it wasn't.
Yeah.
I'm just pointing out that, as I said at the outset, the Lord President was right. The Lord Drummond-Young doesn't give any particular reasons in the light of the Valiano case as to why it isn't. But as I say, I'm just taking your lordships to what the general approach is in relation to the code, and it's page 1576 to 7 in the speech of Lord Herschel, at the bottom of page 1576 until the middle of page 1577. And it is in relation to the Bills of Exchange Act 1882, which is one of the clearest drafted statutes on the statute book. And he says it was intended to be a code of law relating to negotiable instruments, and so that the court should examine the language of the statute, ask its natural meaning, uninfluenced by considerations derived from previous state of the law, not to start with inquiring how the law previously stood, and then, assuming it was intended to leave it unaltered, to see if the words of enactment will bear an interpretation in conformity of the view. If a statute intended to embody in a code a particular branch of law is to be treated in this fashion, its utility will be almost destroyed if effectively you start the antiquarian archaeology. The purpose of such a statute was to allow the law to be ascertained by interpreting the language used there, instead of roaming over a vast number of authorities in order to discover what the law was, extracting by a minute critical examination of prior decisions, dependent upon a knowledge of the exact effect even of obsolete proceedings, such as the demurrer to evidence. For frankly, those observations apply here in relation to looking at cases in 1842, albeit reported to the whole court from the second division. It's fairly obscure stuff. And of course, as Lord Herschel notes, he's far from asserting that resort may never be had to the previous state of the case law for purpose of aiding construction of the provisions of the code. If it's of doubtful import, it might be perfectly legitimate. Or if there are words to be found which have acquired a technical meaning, and that's basically what we said, that certain words are used. It's on the assumption that they are understood as they were at common law, but that doesn't mean you can then go out with the terms of the four corners of that code. But as he says, what, however, I am venturing to insist upon is that the first steps taken should be to interpret the language of the statute, and that an appeal to early decisions can only be justified on some special ground. And that's not the case here. I say that no special ground has been set out.
What is the basis, Mr. O'Neill, what is the basis on which you say that this aspect of the Debtors Scotland Act, it was intended to be a codification of all aspects of diligence on the dependent?
Simply from its terms and the history of its enactment, it was clearly, my lord, a response to ensure that diligence on the dependents and the granting of inhibitions, it was seen as your lordship doubtless aware, by the Law Commission to be problematic, and that in response to concerns, academic concerns from the Law Commission, and also as articulated by Lord Drummond-Young in the Carl construction case, the legislation came in and set out common structures across the Court of Session and the Sheriff Court, and in that sense, it seems to it is a codification. It says you don't have to look through all the authorities as to how and when to apply, and the procedures are set out. I mean, it's a position, my lord, and it was a position that was taken by the Lord President in this case.
Well, I'm trying to test the position. Was there anything in the explanatory notes in the Bankruptcy and Diligence Scotland Act 2007 which supports the assertion that this was meant to be a complete codification of all aspects of diligence on the dependent?
Those, well, my lord's asking a slightly loaded question by putting in all aspects of the diligence on the dependents. I haven't checked the explanatory notes. Again, my lord, because as I said before, I'm not putting a positive case here. I'm setting out the debatable aspects of this such that it is not properly implementation for the purposes of EU law. And the fact it's debated is shown by the fact that the Lord President thinks it's a codification, and if it's a codification, this is what happens, and the Lord Drummond-Young thinks it's not. But it is not necessary, for my purposes at least, for this court to decide as to whether it is or is not a codification, which is why your lordship has not been burdened with excessive materials on aspects like this. But we're more than happy to produce those explanatory notes if your lordship would think it would be useful in coming to a decision.
I have them in front of me, Mr. O'Neill, and it says this new part sets out a new regime for granting execution effect and recall expenses in diligence on the dependents and replaces some of the pre-existing common law rules. So I mean, it abjures.
Your lordship is ahead of me as ever.
It abjures any codification.
No, your lordship can no doubt put that in your judgment and explain why the Lord President got it wrong. It seems to me, and use of explanatory notes in this way without actual submissions on the matter is perhaps not the wisest course, but if your lordship doesn't need submissions having read it, then there it is. But as I say, it is not a central aspect to my claim.
I've brought it up in front of me in response to your submission, Mr. O'Neill.
Well, I'm obliged, Lord, but your
can I refer you to paragraph 451 of the explanatory notes?
Well, Lord, I don't have those. I would then have to, I have a limited time. I can certainly, and your lordship would be wanting, if you like, ask me to draft on the hoof. I will certainly have a look at those and any other relevant materials if your lordship thinks this is relevant. But as I say, all that I'm pointing out is that this is a debatable and debated matter. Your lordship does not have to, of course your lordship is more than welcome to decide actually Lord Drummond-Young was right on this, but it doesn't take away from the fact the issue is disputed and was found otherwise by high authority. But that's as far as I need go. So in sum, there are a whole series of arguments to suggest that the course of action which has been submitted as implementation of this EU directive is simply not available. It's simply incompetent. There have been a whole series of legislative developments which have not been taken into account by Lord Drummond-Young, in particular the provisions of the 1982 Act and indeed the 2010 Act insofar as he relies on arbitration. And he rejects the approach taken, which the Lord President accepts, of the 1987 Act provisions being in effect a mini code of the issues. But as I say, that's enough to raise doubts to say there isn't therefore the clear and precise implementation of the rights of the individual to effective protection, such as are required to her as a matter of EU law. Right, and finally, apart from the whole issue as to whether or not the Sheriff Court has any kind of jurisdiction, which we've already touched on, finally, if your lordships are, however, persuaded that Fordyce and Motorcraft and Hawkins apply to the Court of Session in terms of its inherent or supervisory jurisdiction, and that therefore an application can be made to the Court of Session, then of course we have the big issue of the expense associated with Court of Session procedure involving the instruction usually of two lawyers, an instructing agent and a solicitor or advocate with higher rights. And the costs of that are, in fact, have been looked at in the in the materials provided by the intervener in the affidavit of Ian James Rutherford. I wasn't particularly going to take your lordships to that, but pages 681 to 682 sets out the kind of monies we're looking at for taking an action for diligence before the Court of Session, and it's at least £1,500 with counsel or solicitor advocate fees on top of another 1,500 to 3,000 more if senior counsel come along. So, in sum, the respondents claim that there is an alternative remedial base for interim protective orders to be pronounced in the Sheriff Court is wholly untested, without precedent, theoretical, doesn't take into account the relevant statutory framework, and in any event, even if it is available, even if my Lord Hodges is persuaded that this jurisdiction has survived the ravages of time, it's still not implementation of the rights given under EU law to the level required to ensure there is no breach of EU law in that. So, as I say, it's not necessary for this court to positively uphold or as well-founded any of these questions I have raised as to the competency of the respondent's approach. All that is required is for the court to take these doubts into account and conclude that the respondent has simply not discharged its burden of proof in showing that its proposed implementations are well-founded and clear and precise as a matter of law, as a matter of EU law. In any event, as I note, in terms of that burden of proof, the respondents simply haven't produced anything apart from antiquarian legal argument, but they then rely on simple bare assertions in their case by saying, for example, paragraph 57, all they're talking about is a modest departure from a favourable regime, and paragraph 58, seeking infant protection in a court only requires modest inconvenience to a party. The additional expense and inconvenience by requiring claimant to raise an action in the sheriff court are modest. Well, it all depends what you mean by modest. We're talking thousands of pounds easily, but from the evidence we've got, when the median income in Scotland is just under £24,500 gross, expecting people to add on £3,000 or £4,000, which they might lose out completely, but certainly they will not recover even if successful in full, because court dues are not recoverable, and the costs of instructing your own solicitor are not recoverable, is, I say, manifestly a failure in proper implementation, as is required as a matter of EU law. Now, there's some dispute, at least there's some apparent dispute between the parties as to what the test is, assuming that these implementation measures were indeed clear and precise enough for the purposes of the EU implementation case law. Well, if I get...
Just on the question of costs, if you are unsuccessful in the employment tribunal, and suppose you've succeeded in getting an arrestment in advance, but you then lose on your claim, could you end up having to pay the defender's costs in relation to the arrestment?
Well, the normal rules as they currently stand, and of course we're now speculating what the rules might be, but the normal rules, as your lordship's aware in employment tribunals, is it's got to be vexatious or frivolous before a costs award.
Yeah, I know that's in the. That's why I'm asking you about. I'm assuming that you've gone to the sheriff's court to get the arrestment, that it's available there. I'm asking then whether you might be in a worse position than if it had been available in the employment tribunal, because you could end up with not only, you said, bearing your own costs, but could you end up with a liability for the other side's cost?
You could do if you went over the current statutory test of saying that the arrestment, you'll get the costs for the failed arrestment in the sheriff court, and presumably that could be used as a factor for saying you should also exceptionally get the costs against you in the employment tribunal because it was a frivolous and vexatious action completely to begin with. But it's a fairly high hurdle, though. But it would be a relevant factor potentially.
So I'm not sure whether you answered the question. I was just asking quite a simple question, which is if the arrestment turns out not to have been necessary, the defender who's been involved in the proceedings on the arrestment could end up getting an order for costs in its favour in the sheriff's court or the court of session, or not? Yes,
I think so. Yes, because you wouldn't then be applying for arrestment in execution, because the and so the inconvenience would probably be reflected in costs. I don't know. Does that answer the question, Lord?
Yes, thank you. Yes, it does.
So, yes, there was a dispute about assuming we get over the clarity measures requirements under EU law from implementation as to whether or not how does then one assess whether or not this alternative remedy is compliant with EU law. Basically, what was argued by the other side that the test which is to be applied is a renvoi back to national law standards, i.e. is this protection equivalent to what's afforded to other similar claims, and doesn't make it impossible in practice or excessively difficult to vindicate the EU law claim. And it was argued on my side that in fact the test is not a renvoi back to national law. It's a question of a base level of protection, effective judicial protection in EU law, and that's clear from the terms of Article 19(1) of the Treaty on European Union, which says that in fields covered by EU law, the member states should ensure effective judicial protection of rights, and Article 47 of the Charter. It's an interesting academic point. It's in development, but the fact is that Lord Drummond-Young in the court below said that the test was one of EU law proportionality, and that is not cross-appealed against, and in fact the other side actually agree that that is the correct approach. So it's the EU law proportionality test in the same way that was applied by this court in the Unison case. So we don't have to, therefore, get into and resolve the issue about equivalence and effectiveness or the like. It's EU law proportionality which is being applied here. And that's against the background, as we know, that so what would be the proportionality of introducing or requiring that remedies for the breach of the substantive rights be taken before the Employment Tribunal, which, as this court mentioned in the Michalak case, sets out a comprehensive range of remedies, which is specialist, has exclusive jurisdiction, experience and expertise, and does not normally involve any kind of cost exposure. Against that background, can be said to be proportionate for there to be a requirement to also nonetheless go to another court for a protective order. Now, I say, as your Lordship's already heard, under the Workplace Relations Commission case and the Aarhus case, is that EU law, or the ECJ, certainly expects that it be the one court which has custody over both matters, and that splitting of these matters is not proportionate, unless there are very good reasons as to say why it should not be. And the fact that the Constitution required it was not a good enough reason in the case of the Workplace Relations Commission case. And I say, frankly, that nothing that has been set out by the respondent shows that they have established it is a proportionate requirement in the circumstances of this case. All you get are these bare, unevidenced assertions about it all being terribly modest, whereas the facts that are before this court show that it would in fact be cause the result for individuals to be excessively difficult. And that was the test, at least, which the Lord President applied. He noted at paragraph 14 of his judgment at page 146 of the core bundle, just sets out typical claimants would not normally have the services of a law agent. Legal aid for employment tribunal cases is limited, often just party litigants. If a claimant required to apply to a court for protection, she would have to move from the informality of the ET to the formality of the court, would have to instruct lawyers, would have to get paid court dues. Court dues in the sheriff courts are in the hundreds of pounds, but in the Court of Session are incredibly high if there's any kind of disputed hearing. We're talking of £300 per half hour. And once in the court system, of course, is then the liability to a possible award of costs or expenses against one, as Lord Leggett has pointed out. And as the Lord President says, all this moves the level of cost, accessibility and convenience into another dimension in comparison with just a form-filling exercise before the ET. For that reason, he says, in securing an effective remedy is practically impossible and excessively difficult for a number of claimants. And I agree with that on the basis that that wording is simply his application of an EU law proportionality test. He's applying the same test, as I said, was applied by this court in unison. In any event, because we are in the realm of fields covered by EU law and the right to an effective remedy under Article 47 of the Charter, then any limitations on that right have to comply with the requirements of Article 52. Again, this is how this court approached it in unison. And that requires that the requirement which the respondent says has to be done to raise a separate protective action has to have been duly provided for in national law. And I say, given the debatability and obscurity of this case, there hasn't been due provision by national law. That is a qualitative assessment, as is well known to this court from cases such as Christian Institute and T against the Chief Constable of Manchester. It's not simply saying, well, there is law there. The law has to be accessible and foreseeable and comply with the requirements of legal certainty. And in any event, it doesn't respect the essence of the right of an effective remedy under Article 47 and cannot be said to be necessary in the proportionality sense. So, finally, there are some issues around equivalent or treatment if one wants to go down the issue of equivalence. And again, there's a dispute, and again, not really much jurisprudential discussion. Basically, there are two choices. If you're looking for an equivalent claim, you can say, well, employment tribunal claims for unfair dismissal are being treated in the same way as Equality Act claims, workplace-related or Equality Act claims in the employment tribunal. So therefore, that is equivalent treatment. The alternative is to say, you don't look at what happens in the employment tribunal, but rather look at how the EU principle of non-discrimination, which is set out in the directives, which in the case of the race directive and the sex discrimination directive applies not just in the workplace, but also in the public square in terms of provision of goods and services. And the provision in goods and services aspects, which are covered by EU law when it comes to race and sex, are to be pursued in the Sheriff Court, and you can get your interim orders and protective diligence there without raising a separate action. And so there is, looking at it from the perspective of how are the EU law provisions duly protected, you say that the employment tribunal, the ones covered by the employment tribunal, you have to go to another court, whereas those discrimination cases within the jurisdiction of the Sheriff Court, you're already in the same court, and therefore there isn't the double whammy of going to two courts. But you know, this is a matter of judgment. It isn't a hard science, but those are the two arguments pressed. And I say that if you're looking for how equivalent cases are treated, then look at how discrimination is looked at. If you do that, then the obligation as a matter of EU law of equal treatment is to ensure as it were, the levelling up of protection rather than the levelling down. But in a sense, none of this needs to be determined by this court again, because, as I say, I'm pinning my flag to the fact that the obscurity, the lack of statutory provision, the fact that one has to, as it were, research in an area which is highly debatable and has required to come to this court for clarification, means that at the time this individual was seeking the vindication of her substantive rights before the employment tribunal, there was not adequate implementation of her rights to effective remedy and dissuasive sanction, such as were expressly set out in the terms of the directives, which formed the basis of the national rights upon which she relied. So, in all those circumstances, my lords, I say that this appeal should be upheld, and the specific order which should be granted is that which was suggested by the Lord President in relation to which pleas and law should be upheld and which should be repelled. But basically, and go through the mechanics of that, but the Lord President set it out. But basically, it requires the matter to be remitted back to the Outer House for the issues around causation and quantification of damage falling on from the establishment of this breach of EU law in terms of failure of implementation to be reconsidered, to be taken up and considered by the court. So, my lords, that's all I would have to say in my principal submissions, unless there are particular points which need further clarification.
I don't see any of my colleagues asking you for further clarification, Mr. O'Neill. Thank you very much.
Obliged, my lord.
Mr. O'Neill.
My lords, I begin by adopting my written case, which begins at page EF 121 in the bundle. And I also begin by noting that the Commission's submissions in this case are premised on two assumptions. The first assumption is that the courts below were correct to find that it would be competent for a claimant such as Ms Anwar to bring parallel proceedings in the Sheriff Court to obtain diligence on the dependents. That question of competence is one in which the Commission does not make positive submissions one way or another. If Mr O'Neill is correct on the question of competence, then the Commission's submissions are irrelevant. The Advocate General agrees that if interim diligence is not available, then that would constitute a breach of EU law. And that's the Respondent's case at paragraph 67,119 of the bundle. The second assumption is that the test of effectiveness is as articulated by Lord Drummond-Young. That is, that the rules governing actions derived from community rights, community law rights, must not render the exercise of those rights practically impossible or excessively difficult. The Commission has sought to provide the Court with information about the practical experience of and the challenges faced by claimants in the Employment Tribunal, and with information about the reality of the process of bringing parallel proceedings in the Sheriff Court. The Commission relies on material that is not specific to the appellant's circumstances for the purpose of assisting the Court to test certain assumptions about the nature of the burden to be borne by a claimant in bringing parallel proceedings. Assumptions were made by the Lord Ordinary at first instance, by the majority in the court below, and by the Advocate General about the simplicity of the process and about the modesty of the inconvenience and cost involved. So far as assumptions about simplicity of process are concerned, those assumptions are made in my respectful submission by senior lawyers with very substantial experience in the higher courts, but not with recent experience of litigating in the Employment Tribunal or the Sheriff Court, and who will find it inherently difficult to assess the issue of complexity or formality from the perspective of a claimant in the Employment Tribunal. The assumptions about expense or relative inexpense of bringing proceedings have not been grounded in the courts below in information about the actual costs involved or the circumstances of claimants before the Employment Tribunal. They do not, in my submission, reflect the policy reasons why Employment Tribunal proceedings are generally cost-free. The Advocate General, as has already been noted, criticises the appellant for failing to provide evidence that the additional costs involved would be, and I use his word, significant. That's at paragraph 33 of the Respondent's case. But the Advocate General himself provides no amplification of what would be considered significant or how that is to be measured. The Commission's position is that when the Court understands the context in which a claimant such as Ms Anwar is seeking to enforce her rights and the practical requirements of parallel proceedings, it's clear that parallel proceedings do not provide an effective remedy as a matter of EU law and by reference to the requirements of the European Convention on Human Rights. In considering whether procedural requirements meet the test of effectiveness, Lord Drummond-Young referred in the court below to the case of Impact against the Minister for Agriculture and Food, in which the Court of Justice held that the requirement to bring two different sets of proceedings for the enforcement of rights would be contrary to the principle of effectiveness if, and I'm quoting, it would result in procedural disadvantages for those individuals in terms inter alia of cost, duration and rules of representation such as to render excessively difficult the exercise of rights deriving from the directive. Impact is at tab 53 of the bundle. I was quoting from paragraph 51, which is at page 2199. And clearly the list of factors mentioned there, cost, duration and rules of representation, were not exhaustive. Lord Drummond-Young cites this summary in Impact, but then describes the test as being whether procedural requirements, he uses the language of requirements, render enforcement excessively difficult. Impact uses the language of procedural disadvantages and of procedural complications. There may or may not be a difference between those and procedural requirements, but in my submission, the issue is the cumulative impact of the various procedural hoops that may have to be gone through, rather than looking solely at the procedural requirements of one or other process alone. And the Advocate General accepts at paragraph 56 of his case that the requirement is to examine the procedural regime in context and as a whole. That this court should have regard to the reality of the obstacles that arise is a matter obviously of common sense, but it is all the more necessary in my submission where the question before the court involves compatibility with Article 47 of the Charter, which must be interpreted by reference to Article 6 of the Convention, and the requirement that the protection of rights is not to be theoretical and illusory, but practical and effective. And in unison, of course, this court was clear that these EU law requirements interpreted in light of the Convention were, and I'm quoting, consistent with the recognition in domestic law that the impact of restrictions must be considered in the real world. Unison's at tab 10 of the bundle, that was paragraph 109 at page 1175. So my lords, I have said that the court ought to have regard to the context in which claims are to be enforced and to the practicalities of obtaining diligence on the dependents in parallel proceedings. So far as context is concerned, that's set out at section 2 of the Commission's case. And the first key factor, so far as context is concerned in my submission, is the nature of the relationship within which these EU law rights fall to be exercised and enforced. It is undoubtedly trite, but it's nevertheless important to record, as it was recorded by this court in Unison, that the imbalance of economic power between the employer and the employee, and to record that this imbalance results in vulnerability of employees to exploitation, discrimination and other undesirable practicalities or practices. My lords, the Lord President was of the view that the imbalance in the economic powers of employer and employee had been widened by the development of the Employment Tribunal in place of ordinary courts as the forum for employment claims. That's at paragraph 10 of the Inner House decision at 144 to 145 of the bundle. That seems counterintuitive. That conclusion flows, I think, from his view on the question of competence, that an employee not being able to seek diligence on the dependents either in the tribunal or indeed in the ordinary court had widened that imbalance of power. But even if the Lord President is wrong about competence, it may be said in my submission that the imbalance of power is exacerbated by putting a further obstacle in the way of an employee seeking to secure protective measures. The inherent vulnerability of employees that results from their unequal economic power may be exacerbated by other vulnerabilities. In Ms. Anwar's case, the Employment Tribunal accepted evidence that she had moderate depressive disorder and moderate to severe post-traumatic stress disorder attributable to the discrimination, harassment and victimisation that she had suffered. And the reference there is the Tribunal's judgment of the 24th of August 2016 at 271 of the bundle. And in my submission, these kinds of impacts are a regular feature of employment law claims. This court in Unison also recognised that the Employment Tribunal was designed to mitigate the impact of these inherently unequal power relationships, with features including the absence of fees, clearly post-Unison, relative informality of process, and protection against adverse awards of expenses. Notwithstanding those features, it's clear that many claimants do not obtain a remedy because they were not able to secure enforcement of awards in their favour. The appendix contains various reports produced in the period 2009 to 2017, which concern, among other things, enforcement of employment tribunal awards, and which were before the courts below. These documents have been added to by the Commission in this appeal by the inclusion of two more recent documents. First, the UK Government's consultation on the Taylor Review's recommendations on enforcement, and second, extracts from the United Kingdom Government's Labour Market Enforcement Strategy 2018 to 2019. Those two documents are items 4 and 5 in the interveners documents and run from pages 687 to 813 of the bundle. Now, the key points that the Commission draws from those reports are summarised at paragraph 2.6 of the Commission's case. I don't propose to take the court to each of those reports, but I would draw out the following general points as arising from them. The first is that problems with enforcement of employment tribunal judgments is a long-standing problem and is one which is well known to the United Kingdom Government. Its most recent recognition was in the consultation on the Taylor Review's recommendation on enforcement of employment rights. And your Lordships will see, for example, at the that point at the executive summary at page 695 of the bundle, and in its proposals for reform of enforcement of awards, which is at page 699 of the bundle. Second, claimants in Scotland were significantly more likely to say that they could not afford further action to try to recover the award. And that's the 2013 report at page 471 of the bundle. And it was surmised in that report that the reason for that finding may have been due to the relatively greater cost of engaging a sheriff officer in Scotland in comparison with the costs of the fast-track scheme and the county court in England and Wales. Next, rates of recovery for Scottish claimants, even after enforcement action had been taken, were lower than for claimants in England and Wales. That's at page 476 of the bundle and is again from the 2013 report. And finally, while insolvency of employers is part of the picture, in my submission it's by no means the whole picture, and the issue of phoenixing is also a problem. That's referred to in the 2013 report at page 472 of the bundle, and more recently in the Labour Market Enforcement Strategy document at page 797 of the bundle. Now, Lord Drummond-Young, in response to the reports that were before him, said that the figures were, and I'm quoting, clearly disappointing, but that the fundamental problem may well be that of insolvency. At the very least, it is impossible to draw the conclusion that Scots law does not provide an effective remedy on the basis of such statistical evidence alone. Now, clearly the Commission agrees that the reports are not conclusive on the issue before this court. However, the Commission's view is that the figures are more than disappointing because they paint a picture of widespread difficulties for claimants seeking to enforce their rights under UK and EU law. And the Commission also agrees with the Lord President's conclusion that what the statistics do is point to the need for the existence of protective measures as are available in a court process when the circumstances merit their use. That's the Lord President at paragraph 12, page 145 of the judgment. So that's the context within which the question before this court arises. So far as the practical requirements are concerned for claimants who might wish to raise parallel proceedings if those are indeed competent, the Lord President concluded that an effective remedy would be for many claimants practically impossible or excessively difficult by reference to a number of specific factors. And I'm going to come on to those factors. The Commission addresses those factors under reference to the affidavits that have been lodged by it. So first, Mr. Rutherford's affidavit explains the process of obtaining diligence on the dependents by reference to the steps prescribed by the 1987 Act. In my submission, and I don't take this to be disputed, in my submission, his description of the process is uncontroversial. I should say and make it clear that his affidavit describes the process and the costs that apply in an ordinary action in the Sheriff Court. That's to say, an action where the sum sued for is more than £5,000. The court costs relating to claims for less than £5,000 are slightly less than in an ordinary action, and there are limits in such cases on the extent to which the court can make adverse awards of expenses. However, Ms. Anwar's case would clearly fall within the ordinary action bracket, and I should say, while it's not before the court, I have considered the most recent Ministry of Justice statistics on employment tribunal claims, and the mean and median figures for discrimination claims and indeed for unfair dismissal claims all are in excess of £5,000. So an ordinary action in the Sheriff Court is a reasonable comparator or example in my submission. Now, the Commission accepts the Advocate General's response that some of the steps which are described by Mr. Rutherford in pursuing parallel proceedings would also be needed in the Employment Tribunal if diligence on the dependents was available in that forum, not least to ensure proper respect for the Article 1, Protocol 1 rights of the employer. However, not all of those steps would be required. In particular, assuming that an application for diligence on the dependents is treated in the same way as other applications before the Employment Tribunal, the applicant would not be required to pay fees. She would not face the requirement of formal written pleadings in the Sheriff Court or indeed in the Court of Session. She may, in the context of an Employment Tribunal, be more prepared to make an application without the support of legal representation, and she would not in the Employment Tribunal be exposed to the risk of an adverse award of expenses simply by virtue of making the application. So far as formality and complexity are concerned, those are dealt with at paragraphs 4.5 to 4.8 of the Commission's case. And in my submission, those factors increase the likelihood that a claimant would need legal representation to deal with matters effectively, or at least would increase the likelihood that the claimant would be dissuaded from proceeding without legal representation. On cost, the minimum cost of bringing an application in an ordinary action in the Sheriff Court and of obtaining warrant for an arrestment on the dependents is £181. Those are the court fees. That's the cost of an initial writ, the originating writ in the ordinary action, together with a motion for diligence on the dependents. And those costs are set out in Appendix 2 to Mr. Rutherford's affidavit, which is at page 683 of the bundle. That's if a litigant proceeds without legal representation. If they do seek legal support, the cost of their solicitor's fees would be on top of that cost. Now, Mr. Rutherford's estimate is based on 5 hours of work from being instructed to bring proceedings to the point at which the warrant for arrestment on the dependents is obtained and served. The cost he attributes to that is £900, inclusive of VAT. That's based on an hourly rate of £150 an hour. And as I said in the case, £150 an hour is less than the judicial rate currently available for recovery of expenses in the Scottish courts. That rate is currently £164 an hour. So in my submission, both the amount of time estimated by Mr. Rutherford and the hourly rate attributable to that time is I think I've used the expression lean, and is certainly modest. Ms Bowman, there is an affidavit from Ms Alice Bowman, who is the only solicitor that the Commission is aware of who actually attempted to bring parallel proceedings. Her affidavit describes costs well in excess of those estimated by Mr Rutherford, although I accept, and I should make it clear, that the work involved on Ms Bowman's part was not only in relation to the application for diligence on the dependents, but in connection with obtaining anonymity for her client in the Sheriff Court proceedings, which again might be expected to be something which an employment tribunal claimant might seek in the Sheriff Court. But nevertheless, looking at Ms Bowman's affidavit, it's clear that even the process of obtaining diligence on the dependents involved rather more work than the modest estimate given by Mr Rutherford. In my submission, the risk of an adverse award of expenses is liable to create a deterrent effect, and that's by reference, amongst other things, to the factors mentioned by Lord Reid in unison at paragraph 28, which is at 1155 of the bundle. Those factors, and in that context he was dealing with recoverability, those factors include that prediction of success is not an exact science. Reliable prediction depends on legal judgment that may or may not be available, and the substantive law in this area involves a degree of complexity and technicality. And Mr Rutherford's affidavit at Appendix 3 sets out the potential exposure of a claimant where an adverse award of expenses is made against them, ranging in the Sheriff Court from £205 to £492. That's at EF 685. Now, my Lord Legate asked a question about adverse expenses of my learned friend Mr O'Neill, and the relevant provision on the expenses of diligence on the dependents are contained in section 15M of the 1987 Act, which is at EF 842, and your Lordships may wish to look at that briefly. Subsection 1 provides that subject to subsection 3A below, a creditor, so here the claimant, shall be entitled to such expenses as they incur in obtaining warrant for diligence on the dependents, and where an arrestment or inhibition is executed in pursuance of the warrant, in so executing the arrestment or inhibition. So there is a presumption that a claimant will be awarded their own expenses in relation to obtaining the warrant for diligence on the dependents and executing it. However, that is subject to subsection 3A, and subsection 3A, which provides that the court may modify or refuse such expenses as are mentioned in subsection 1 above, if it is satisfied that 1, the claimant was acting unreasonably in applying for the warrant, or 2, such modification or refusal is reasonable in all the circumstances and having regard to the outcome of the action. So I think that answers the point made by my Lord Legate that a claimant might obtain diligence on the dependents if that is competent, but at the conclusion of their claim in the employment tribunal, if they have failed to persuade the employment tribunal of their case, they would face the potential of an adverse award of expenses being made by the Sheriff in relation to not only the application for diligence on the dependents, but of course the substantive Sheriff Court action as well, because that action would fall to be dismissed or abandoned. This deterrent effect is relevant in the context of EU law in relation to interim relief, and I've made reference in the case to the Commission against the United Kingdom, the Aarhus case, to which your Lordships have already been taken. That's tab 48 of the authorities, beginning at 1996 of the bundle. And that case was, of course, concerned with transposition into domestic law of directives on participation in environmental decision making, and the requirement that review procedures should not be prohibitively expensive. The court was clear in that case that the financial risk for a client of having to give a cross-undertaking in damages in relation to interim relief had to be included in the assessment of whether proceedings were prohibitively expensive. So, my Lord, in my submission, taking these factors together, complexity, formality, cost, and the risk of an adverse award of expenses, altogether these render it unrealistic and unreasonable to expect a claimant to follow that route, and in my submission renders that remedy, if it is available to a claimant, one which is excessively difficult for the purposes of EU law. Lord, I wish to address a few further matters arising from the affidavits lodged on behalf of the Commission. The Commission has filed an affidavit from one of its officers explaining a survey of employment lawyers and lay representatives that it conducted last year. And I accept that that survey was relatively limited in terms of its responses, and I wouldn't attribute to it greater weight than it can bear. However, what I take from the survey results and from the evidence of Ms. Bowman in her affidavit are the following general propositions. First, employment lawyers are not familiar with processes for obtaining diligence on the dependents in the Sheriff Court. They rarely, if ever, advise clients to pursue such processes, and that, at least in the case referred to by Ms. Bowman, doing so involves greater time and expense than might be the minimum to be expected of such an application. Now, none of that, I accept, can speak to the question of the competency of parallel proceedings. What it does speak to, and in my submission this is relevant to the question of effective remedy, is the reality of the specialisation of legal advisors, reflecting the specialist nature of employment law and of the Employment Tribunal as a forum. And that specialisation is not an accident. It's an inevitable consequence of the creation of the Employment Tribunal as a forum for these claims. It's also a consequence of the way in which the United Kingdom has decided to organise its regime for the protection of employment rights, including rights derived from EU law. It points, therefore, in my submission, in the real world to the desirability and I would say the necessity for a claimant to be able to access their remedies through that single forum. On the same theme, the Commission would question Lord Drummond-Young's analysis that there are good practical reasons for keeping questions of diligence on the dependents in the Sheriff Court rather than the Employment Tribunal. Lord Drummond-Young characterises diligence as raising a range of legal issues not related to employment law and therefore not suited to the Employment Tribunal. The first response, I think, has already been made by Mr. O'Neill, that the first question a sheriff would have to address in considering an application for diligence on the dependents is whether the claimant has a prima facie case on the merits of his or her Employment Tribunal claim, and that's inherently going to involve questions of employment law. A second response is that the Employment Tribunal deals with a range of complex matters on a daily basis, including issues that involve balancing the rights of employees and employers and issues arising out of the employment contract. So in my submission, there is no great objection to argue that the Employment Tribunal would not be fit to deal with diligence on the dependents. Now, the Advocate General goes further and contends that requiring applications for diligence to be made before a civil court serves in a proportionate manner the legitimate aim of taking appropriate account of the interests of the person against whom the order is sought. That's at paragraph 65 of the Advocate General's case at page 119. That legitimate aim is also said to include the need to have the decision made by the most appropriate decision maker and to impose on the applicant in an equitable manner the expenses occasioned by an unsuccessful application for diligence. I've already dealt with the question of expertise, but it's not obvious to me why in this particular kind of application and not in others before the tribunal, the right of adverse expenses should be available. More importantly, in my submission, there is no material from the Advocate General or the United Kingdom Government to suggest that the Government applied its mind to these factors and made any conscious decision. that diligence on the dependents ought to be available in the ordinary courts rather than in the tribunal. Rather, the history appears to be more likely to be that described by the Lord President at paragraph 10 of the Inner House judgment. Essentially, in his analysis, when employment tribunals were established, it was accepted that diligence on the dependents shouldn't be available, given the nature of the claims being dealt with in the early days and the limited nature of financial awards, but that matters have moved on. Employment tribunal awards have increased, and it appears that the position on diligence on the dependents has not been actively revisited. My Lords, I should touch finally on the question of convention rights. The Commission invites the Court to have regard to convention rights issues in resolving the question before it. The appellant, of course, has not relied on convention rights in this case, and that may be unsurprising given that it's a claim articulated as one for Frankovich damages. The Commission sets out in its case at paragraphs 5.1 to 5.5 the relevant principles. It seems uncontroversial that Articles 6 and 13 of the Convention are relevant to the principle of effective judicial protection as a general principle of EU law and to the proper interpretation of Article 47 of the Charter. Article 6 encompasses the right to have a binding judicial decision enforced. That right is a concomitant of the right of access to the court, and so the distinction made by Lord Drummond-Young and by the Advocate General between the right of access and the issue of enforcement is, in my submission, a false one. The right of access must not be theoretical and illusory, but must be practical and real, and that's of course unison at paragraph 109. The right is to have a final decision enforced, and the state must organise a system of enforcement that is effective in law and practice. And in the Commission's submission, that includes a system that provides for effective interim protection if, without that protection, the right to enforcement of the final decision is jeopardised. And my Lord, to conclude by reflecting on the lower courts have said to the effect that the Convention adds nothing to the EU law arguments in this case. In my submission, the Convention adds the following. It reinforces the point that in assessing whether the appellant's right to an effective remedy has been met, a practical approach requires to be taken by the court. It's a reminder that the issue before the court is not one that's relevant only in the context of EU law. And finally, the Lord President may be correct that the common law would be sufficient protection, but if he is not, then the obligations of the UK under the Convention and the obligations of this court and the UK government under the Human Rights Act would fill any gap. Lords, I'm conscious that I think I am now at the end of my allotted 30 minutes. I don't know, my Lords, if there are any questions on my submissions, but otherwise, those are my submissions.
Mr. O'Neill, thank you. It's 5 to 1. You're not quite at the end of your 30 minutes, but if you've completed your submissions, that is fine.
I think my Lord, my learned friend Mr. O'Neill would contend that he banked 5 minutes or so earlier in the afternoon. So
you're quite right. Mr. O'Neill is nodding vigorously to bank his 5 minutes. You're quite right, Mr. O'Neill. Well, thank you very much for your submissions. I don't see any questions from my colleagues. Mr. Johnson, do you wish to introduce your case, or do you wish to leave that till after the short adjournment?
My Lord, I'm quite happy to make a quick start just to sketch out where I plan to go, if that would be helpful.
Well, let's do that. Thank you very much.
Thank you, my Lord. The first thing I'll say is that I don't have a huge amount to add to the written case, although what I do say will mainly be in response to what's been said this morning, and in particular to the various points that emerged from the interveners' submissions, which of course were lodged at the same time as our own. The ground I'll cover, I'll break up into essentially two areas. The first one is the Scots law point, which includes but is not limited to the 19th century cases. And the second one is the effectiveness of the remedy, which obviously can be scrutinised under common law or under EU or indeed under convention law. So if I come then to the Scots law, which I can deal with quite briefly, although not entirely before the lunch break, I should say this, it's not our position that in 1842 there was some preemptive implementation of EU law. Our case is not based on the 1842 case law as implementing the directives. Our case rather relates to the content of the 1987 Act, which contains the substantive provisions on which the diligence on the dependents is made available in the courts. And my lords will see that if they reread at some point the written case. Starting at paragraphs 8 to 20, we have made detailed submissions about the content of the
You're breaking, Mr. Johnson. You were breaking,
in order to provide.
Mr. Johnson, you were breaking up then. I wonder if you could go back. You referred to paragraphs 8 to 20 of your case. I don't know about my colleagues,
Yes.
but I was then interrupted. Your reception was then weak.
I'm sorry, my lord. Yes, what I was simply seeking to say is that in that part of the case, we have set out how it is that diligence on the dependents is awarded under the 1987 Act by the appropriate court. And it is only later at paragraph 21 following that we come on to explain that the ability of the courts to grant diligence in an ancillary manner to give support to proceedings taking place substantively elsewhere is nothing new, and it goes back at least to 1842. So the foundation of the case is by no means the 1842 case law. That is simply there to show that there's no difficulty with the proposition that the courts have an ancillary jurisdiction, and indeed nothing in the current legislation deprive them of it. My lord, I think that may be the most sensible point at which to break, if I may, and then I'll come back for just a few moments to that point later on.
Mr. Johnson, thank you very much. The court will now adjourn and resume at 2 o'clock. Thank you.